am James Hughes, and together with James Marwick, we are going to be talking to you about the fundamentals of data protection and breach of confidence. And James Marwick is going to deal with, in the second part of the talk, litigation aspects of the data protection regime. Now, if I am able to, I am going to share my screen with you all to set out the presentation slides. Right. So, what you need to know. First, the two key parts of the data protection framework. Those are the Data Protection Act 2018 and the GDPR. And date is important as a starting point. That date is the 25th of May 2018. That's the date on which both pieces of legislation came into force. Our talk focuses on the 2018 Data Protection Act and assumes that your caseload will comprise mostly of instructions about breaches which occurred after the 25th of May of 2018, and so not the old regime under the Data Protection Act 1998. And there's an interplay. It's an important starting point, which I think it's important to grasp and get to terms with, which is the way that the GDPR works with the Data Protection Act. And this talk is going to focus on Chapter 2 of Part 2 of the Data Protection Act, mainly for reasons of time, but also I think because Chapter 2 of Part 2 of the Data Protection Act 18 sets out what you need to know about the GDPR and how the GDPR works with the Act. And the Act mirrors and incorporates the GDPR's definitions, save with some exceptions which you don't need to know about for the purposes of this talk. And the Act itself is split into 7 parts. Our focus is going to be, as I said, Chapter 2 of Part 2. The essential point, though, if your clients come within the following categories, then I think it probably is well worthwhile reading the specific framework for their obligations, which is set out in the other parts of the 2018 Act. So if you've got national security and defence clients, then it's Chapter 3 of Part 2. Law enforcement clients, and so I think particularly there, those will be your police force clients or other associated agencies who deal in law enforcement with the police, then that's Part 3. And Part 4 of the Act, if you're lucky enough to have any intelligence services clients. Terms. So, as I've said, the two pieces of legislation are now the framework for the UK's data protection regime, and everything really falls into place around the terms under the GDPR. So I think it's important that we set out what those important terms are. First of which is what personal data is, as described at Article 1, setting out the legal restrictions contained in the GDPR, and Article 4.1 defines it personal data as any information relating to an identified or identifiable natural person, and that natural person can be identified directly or indirectly by name, ID number, location data, or one or more of physical, physiological, genetic, mental, economic, cultural or social identity of that natural person. So you'll see that that's a very expansive definition of what personal data is. And I think it covers just about every conceivable way you could think about any other living person in terms of their identification. And the Data Protection Act broadly mirrors that definition, albeit it words it slightly differently. And personal data relate to a living individual whose data or other information is in the possession of, or is likely to come into the possession of the data controller. So it doesn't just mean data which the controller is processing, and we'll come on to the definitions of control and processor, but it also means data that they are likely to come into the possession of, and includes opinion about the data subject and any indication of the intentions of the controller or any other person in respect of the individual. So it can include opinion or intention expressed by the controller or any other person. And that's important, I think, for the purposes of vicarious liability, something which James Marwick's going to touch on for you. Some examples of personal data other than name, you have them there. These, I think, are the common or fundamental ones, but there are some other ones which might surprise you, but I think they must follow given the expansive definition of personal data. So date of birth, address, shoe size, NI or passport numbers, blood group, the data subject's favourite restaurant, because that's an expression of opinion about the data subject, whether given by the controller or the data subject, or indeed any other person, geographical location of the data subject, their medical history, or indeed their destination of air travel. So that would include where they're going on holiday, for example. Processing, I've set it out for you as Article 4.2 GDPR defines it, and it's also set out in sections 4 and 5 of the DPA. I won't read the definition out for you, just the same as the other definitions under the GDPR if they're long, but suffice it to say that it covers any operation or set of operations which is performed on personal data. And again, as with identification and what personal data is, processing it is just about anything you can think of, which includes or would include destruction. If you see at the end of the definition in 4.2 of the GDPR of that personal data, that it seems to me is consistent with what the Court of Appeal was saying as long ago as in 2002 in the Campbell and MGN case about Naomi's story as it was published in the Mirror about her drug addiction or alleged drug addiction. And the Court of Appeal said that any information published by or everything in fact done by the Mirror up to and including publication counted as processing of Naomi Campbell's data. Controllers, important here because a good number of you will have clients who are organisations who are data controllers, and the definition is at Article 4.7 of the GDPR, but important it seems to me, it can be a natural legal person, public authority, agency, or any other body which alone or jointly with others determines the purposes and means of the processing of data. And that, as with the definitions of personal data and a processor, it seems to me, is an expansive definition. It can be any other body which alone or jointly determines the purposes and means. So that seems to me is what's done with and how of the personal data. Processor, again, an important definition, but for the purposes of the focus of this talk today, we're going to be looking at what controllers do or don't do and how claimants will allege that that is in breach of the data protection principles or is another kind of unlawful processing. But it's important to remember what processors are, because you may well be dealing with your controller clients who have processing partners who process data on behalf of the controller, typically by an agreement and typically with authority. But so that's important to think about, and that's all Article 4.8 of the GDPR. Data breaches, so the all-important allegation or thing, and how do you spot what? Well, I think it's important to go back to the basics here as they are defined in Article 4.12 of the GDPR, because they can be things that are misunderstood sometimes by claimants who allege them, and it may be that a controller will think that it is in or there has been a personal data breach when perhaps it hasn't. I suspect that the latter probably more unlikely than the claimant getting what a data breach is wrong. But the definition is a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data. And that's a definition which is used repeatedly throughout the GDPR at Article 33, and that's the one with which you will be familiar if you've had controller clients who have had to report personal data breaches to the supervisory authority, which in this case is the ICO, or in our case, I should say, is the Information Commissioner's Office, the ICO. And the threshold for that, something which is relevant to the defence of de minimis, which James will touch upon, is that the controller has no requirement to report a data breach unless such a breach is unlikely to result to a risk to the rights and freedoms of natural persons. I think that's a very high threshold to get over if you're a controller. As I say, we'll come on to that. And again, what a data breach is used in the definition of Article 34 GDPR, which requires by the same kind of token, where there is a high likely to be a high risk to the rights and freedoms of natural persons, then the controller has to report the breach to the data subject as an individual. And what do we mean in practice by what breaches or personal data breaches are? Well, it seems to me they can typically be internal or external. External probably means a third party using illicit means to get at the data, so to access it illegitimately or unlawfully. But that doesn't, it seems to me, just mean hackers in the modern day context. It could mean breaking and entering physically into your data controller's premises. And it can also be an internal breach of security by employees or agents of your organization, which is a controller or processor. And here there is a clear link to the vicarious liability doctrine, which in the data protection context holds an organization liable for the data breaches which have been committed by employees or agents. The more classic breaches that you will be familiar with, and as they are argued, are unauthorized disclosure or access to the viewing of the personal data. But think also about an accidental or unlawful destruction of that data while it's being processed. And also think about data which has been altered or manipulated, and that can be or could arguably be inadvertent alteration of data rather than specifically a deliberate manipulation or alteration of the data subject's personal data. Consent really is an important issue. Many cases will turn on it and whether it was given in respect of the processing of the data by the data subject. Again, I think it's important to go back to basics here. What does the GDPR say it is? And it's defined by Article 411 as any freely given, specific, informed, and unambiguous indication by the data subject, either by a statement or by clear affirmative action, which signifies agreement to personal data being processed. Now, for once with a statutory definition, it seems to me that there's no room for any doubt there about what consent amounts to. It has to be something which the data subject has freely given, not under duress, which is specific and unambiguous. It is, we'll come on to see, a legal basis for processing data both under Article 6 and 9 of the GDPR, that is 6.1a and 9.2a. And where the controller is relying on consent to justify its processing as being lawful, then Article 7.1 of the GDPR requires the controller, so the evidential burden is on the controller to demonstrate consent. And that consent must be clearly distinguishable, it seems to me, from any other matters if it's given in written format. and the data subject also has the right to withdraw it. And importantly, the GDPR at Article 7.3 says that it must be as easy to withdraw consent as it is to give it. Seems to me that three things are clear from the definition. It can't be implied. Consent requires active knowledge and agreement. It can't be imposed on another. But particularly, it seems to me, where there is some kind of power imbalance in the relationship between the subject and the data subject and the controller, which it most clear, it seems to me, when you got a patient or service user client as a claimant that requires care from an organisation like a health board or care home, for example, which is the controller. And you can't imply consent when your clause or notice setting out that consent is complicated or impenetrable. You've got to have, it seems to me, a clearly, simply worded consent clause. The data protection principles, and there are 6 of them now. We'll move on to these. We're getting to what is the heart of the GDPR and the core allegations which a claimant will make in his or her pleading of breaches by a controller, a defendant of the data protection principles. And the controller shall comply with each of them. They're cumulative and they're mandatory. So that's important to remember as a defendant. You've got to show that you have complied with each and every one of them. I've set them out there. Our focus is going to be Articles 5.1 and 5.6 because they are the most routinely and they are the most commonly argued breaches of the data protection principles. 5.1 is lawfulness, fairness and transparency, and 5.6 is protection against unauthorized or unlawful processing and against accidental loss, destruction or damage. So that's the integrity and confidentiality principle, which it also includes, and this is wording which is repeated again in Article 24 of the GDPR, which we'll come on to, the appropriate technical or organisational measures. So as I said, Articles 5, 1 and 6, they're it's the most fertile ground for argument about data protection principles by a controller. Typically, as a defendant, you can expect to see breaches of all 6 of them relied upon by claimants in some way. And as a defendant, you can expect to be able to show compliance with all 6. But as I say, the focus really that you should be thinking about is Articles 5, 1 and 6. And 24, which is another important article, and it's one which is routinely pleaded as a breach argument or a pleaded breach by a claimant. And it provides that by Article 24.1 that the controller shall implement appropriate technical and organisational measures to ensure and to be able to demonstrate that processing is performed in accordance with this regulation. So in terms, Article 24.1 is saying there that you have to put in technical and organisational measures in place to be able to show compliance with Article 24.1 on its own terms, but where proportionate in relation to processing by your controller clients, those measures, and we'll come on to what they are, shall include appropriate data protection policies by the controller. So what do I think that means? Well, it means that a claimant will say that the article or Article 24.1 is widely worded and it's mandatory. Again, the controller shall implement appropriate technical and organisational measures to ensure and to be able to demonstrate compliance with the requirements of that regulation, but also in terms of, as we see again, data protection policies by the previous slide under Article 24.4.2. So that in simple terms means that you should be having, or that the controller should have in place measures at an organizational and technical level to ensure that data remains secure. Now, practically on the ground, and these are the easiest examples that we could think of, and that if you do have data controller clients, these are probably things they're already doing, namely data protection and specifically GDPR training and physical and electronic security measures, things that the computer systems already have. But I think taken together, this is probably the bare minimum of the things that a controller should be doing: firewalls, password protection, encryption, and if data is still physically stored, then you need to have a sophisticated security system to keep it under lock and key. The import of all of that, it seems to me, is that the GDPR is saying that you, as a controller, should be able to show compliance with the terms of the GDPR itself. So you need to show that you've thought about what Article 24.1 says. Now, that it seems to me is a pretty significant thing, because a claimant can say that if that's not done, and it's something which is mandatory and in terms something which should be done under the GDPR, then there is a clear breach of the data protection requirements. Now, the other important article under the GDPR, and along with Article 9, is Article 6, which is the lawfulness conditions article, which provides that in order for data to be processed, that you have to, as a controller, show that you have complied with at least one of the following under Article 6.1. And you've got there each of the subparagraphs to Article 6.1. I won't read them out for you. Again, it's a detailed article, this, but these are the things which a claimant will say has not been done, and the defendant, if in defence of these cases, will show that it has to have done at least one of these things if the personal data concerned is not within the special category of information. So in outline, the most commonly argued lawfulness conditions under Article 6 and what you need to think about when you either are going to put them forward as a claimant or defend these allegations as a defendant are these, it seems to me. Consent, again, obviously being the big one, but some myth busting about it. It's sometimes misunderstood that a controller has to have an individual's consent to process data lawfully under the GDPR, but that's not right, and it's not right even if the data is a special category, so the most sensitive category of data, and we'll come on to that. If you can show compliance with at least one of the other lawfulness conditions, then you don't need to go about seeking out consent on top of that. Though in practical terms, if there has been a breach without consent, then you're not starting from your best place coming out of the blocks for a defendant. But it is right to say that you don't need to go searching out for consent, but starting with consent to process the data in the first place, it is a good idea. If, as a controller, you've got a legal obligation to process data, and it must be, you'll see there the words in brackets, they're important. I think it has to be a legal obligation, then the processing will be lawful. But make sure that it is a legal one rather than something that other organizations are doing in your industry, or something that has been done. And examples there are where statute requires an organization to make a public list of its members. Your controller clients might have to carry out money laundering checks, or your public authority clients that might have an obligation, or indeed other data controllers might have to pass information to the police as a requirement under the law. So that is one way that you can say as a controller that you have processed data lawfully. Other lawfulness conditions, vital interests. Now, this along with public interest and indeed legitimate interests, one of the important terms which the GDPR doesn't define, but Recital 112 to the EU directive which implemented it says that vital interests means or includes physical integrity or life. And that, in my view, means that vital interest probably means the protection of health and well-being, and it probably extends to mental well-being too. Public interest it isn't defined, and here it seems to me there's a crossover, particularly for health board or trust or other healthcare provider controller clients. Equally something that a claimant might be thinking about if they're saying that one of those kinds of organisations has processed their medical records, for example, without consent, then a controller can say, it seems to me, in addition to if the processing is done to protect their vital interests, then that is something you might say is done in the public interest. In any case, there is plenty of case law on what public interest means at common law, and it seems to me that the court would be at least think that that's a good starting point for and a persuasive starting point for what public interest means. The Campbell and MGN judgment is good reading for you on that point. Again, it's a judgment which has cropped up in the data protection context, even if that was a case which concerned misuse of private information and breach of confidentiality, which we'll come on to. And if you've got public authority clients whose power is vested in them by statute, then the bulk of their processing is likely to be done in the public interest, it seems to me, or at least arguably so. Legitimate interest, as I've said, the GDPR doesn't define what that is. So you could have some scope for, or there is scope for some argument there, but it seems to me that legitimate should be the starting point, and beyond that, what your controller does, what their function is, and the intended use of the data are likely to be seen as key points by the court. Recital 47 to the implementing directive, as with vital interests, gives an example rather than what a meaning, though, I should say, of legitimate interests, of where the legitimate interests could exist to the controller, or they could be processed lawfully that way, where the data subject is a client or in the service of the controller. Well, and the recital says that legitimate interests could also be apparent where the processing is done for direct marketing purposes, albeit that I'm a little bit unsure about that. I think it would have to be very valuable market research indeed, and something that springs to mind, something topical at least, is market research that your controller clients might be processing data in respect of those opting out of COVID vaccinations, or those who are not having COVID testing. But again, you could then have an argument about whether or not that's, or it is in a legitimate interest to process that kind of data. Article 9, so the other important breach relevant article of the GDPR. It's a detailed and lengthy one. In short, it protects the most sensitive of personal and private information by putting it into what's called special categories. So they're the special categories of data. And there is, it seems to me here, a link with misuse of private information and breach of confidentiality. Article 9.1, again, it sets out what the special categories of data are. In short, as I say, it's the most sensitive kinds of information about a subject, that racial or ethnic origin, their political opinions, their biometric data for the purposes of uniquely identifying who they are, their health data, or data concerning their sex life or their sexual orientation. And Article 9.1 says that the processing of that data shall be prohibited. So it is in mandatory terms. You can't process that data unless, by Article 9.2, you as a controller can show that the processing was done in accordance with one of the following And again, you'll see there Article 992 sets them out, and there's a great number of them. I won't read them out fully for you, but you'll see that just looking down the list, explicit consent, the vital interests, and exercise or defence of or establishment of legal claims are one of the conditions for processing the special categories of data, as is, again, public interest, preventative or occupational medicine, protecting against serious cross-border threats to health. That, again, topical, it seems to me, which plainly would, in my view, cover processing of data pertaining to the current COVID pandemic or healthcare, the provision of care, or the processing of other data relating to it. And Article 9.3 also makes clear that where data at point F, and just to scroll back to it, that's in respect to processing for preventative or occupational medicine, that data may be processed by persons who are under the responsibility to the data subject and have an obligation of professional secrecy to them. So that it seems to me plainly encompasses an exception to the duty of patient confidentiality, which your controllers in the medical context, health boards and trusts, will have with their patients. So as I said, the conditions and the key points about them, what to look out for. Explicit consent is a condition for the processing of special personal data. It, though, in contrast with the definition of consent given under Article 6, explicit consent, it seems to me, means exactly that. So it's a more robust kind of consent. It has to be communicated by the subject rather than with the authority given by the subject for another to express it. You may have controller clients who process information for the public purposes of employment or social security law, and that, it seems to me, is an essential part of the work of your public authority clients, which allows them to process personal data in that way. And where a data subject can't give consent to the processing of her data, and that data concerns their vital interests, so a patient who can't give consent to the release of records, for example, Article 9.2 would be where you look to justify that processing, and indeed where by definition the subject can't give consent. So again, another example of a situation where you don't need consent lawfully to process data. Charities, that they can process data which touches upon the special categories, provided that the purposes are connected with the aims of that organisation or former members who are regularly in contact with them. Or, as I've said, when you are processing data which touches upon the special categories, if you are thinking about bringing or defending a prospective or extant claim, whether in terms of data protection breaches or generally. We've already touched on the preventative and occupational health aspects of it and the cross-border health element. As I say, I think that there is plainly a cross-border threat to health posed by the pandemic. So that's the way that you could argue as a controller that you are able to process the special categories of a data subject's data pertaining to health throughout this pandemic. So that is, in outline, what I think you need to know in the common arguments in respect of the data protection framework. I'm going to touch upon at a quicker pace breach of confidence and misuse of private information now, because they are the commonly argued other kinds of unlawful processing at common law. Confidence is breached where, and you'll see the three criteria there that Mr. Justice McGarry laid down in the Coco and A.N. Clark case. So the information has the necessary quality of confidence. It's been imparted in circumstances importing an obligation of confidence, and there's an unauthorized use of the information to the detriment of the original communicator of the information. So the burden is on the claimant to establish all of those things. Now, why is that important? It's important because you will have probably seen, if you represent your controller clients, and have probably argued if you represent claimants, that a breach of confidence, it should piggyback on, or it is parasitic on, the allegations of the breaches of the data protection legislation. And the argument usually goes, personal data processed by the controller has a reasonable expectation of confidence, and its communication to a third party, and this I think is important, without the data subject's permission is in breach of that confidence. Though again, you'd have to show to the claimant's detriment. And a defendant will commonly say in reply, this doesn't add anything to your allegations of the breaches of the data protection principles. Misuse of private information. This is a tort created at common law by the Campbell and then really discussed in the greatest detail in Campbell and NGN. There's no doubt, though, that it has an application in the data protection sphere. So the High Court in the Vidal Hall and Google case said, and that's another case that James is going to talk about in his section of the talk, I should say. So it is plainly a tort which has an interplay with, and a legitimate one with the data protection framework. I think the argument from a defendant that this pleading misuse of private information probably doesn't have or doesn't add anything, at least in theory. Whether in practicality it adds anything is another matter, but at least in terms of what the cases say, there plainly is a link with the data protection context. And there's two parts to it. Is there a reasonable expectation of privacy over the information? And if there is, should the court, in carrying out the balancing exercise, prefer the controller's submissions in support of publication or processing? And here, that's where the public interest really comes into play as it's defined in the Campbell case. There's the points I've already made about the interplay between misuse of private information and the data protection sphere. And at that point, I will leave you with James, who is going to deal with litigation aspects of the data protection framework, and he's going to start with remedies.
Thanks, James. Can you unshare your screen? And I think I can take over.
I will do just that. Yeah.
Thank you. Bear with me, everyone, as while I try to get this up and running. Bear with me, display settings. It's taking me right back to the start, testing my tech skills straight away. Let me go through these very quickly. This is a smooth start, just what I wanted. Bear with me and I get there. There we are. Good afternoon, everyone. Thank you, James, for doing the heavier lifting on unpacking the core principles of the GDPR regime. More acronyms than an episode of Line of Duty, I would think. Great TV last night. My segment of this webinar is primarily directed at matters particularly relevant to the civil litigation of claims themselves, in isolation to breach, which James has obviously dealt with. Look, my first, I'll go about 20 minutes or so. So I'm going to aim to about 15 minutes or so. I recognize this is the graveyard shift in particular. The data subject rights, which are protected by the GDPR, are wide ranging, but they are not on the whole particularly groundbreaking when viewed against the data protection 1998 regime. So, for example, the rights I've listed there commence with the Article 15 right, which is a right of access to personal data. That, of course, is a jurisdiction that most of you will be familiar with who deal with this type of work, which is that relating to subject access requests. We all know that it can be weaponized by litigants, particularly if they want to double check whether there's been compliance with the data protection obligations owed to them. The predecessor of that provision was subject of detailed consideration by the Court of Appeal in 2 cases in 2017. Those were Dawson-Damer, that's D-A-M-E-R, and Taylor Wesson LLP, that's a 2017 neutral citation, page 74, and the case of Shane Gardens RTM Co. Limited, another 2017 neutral citation case at page 121. In both those cases, the Court of Appeal rejected the submission that a subject access request was invalid if it was made with a collateral purpose such as litigation. But the Court of Appeal confirmed that principles of proportionality apply implicitly to the burdens of search, analysis, and production which are imposed by a request. Article 15 is enacted as Section 45 of the DPA 2018. It's subject to various restrictions which are embodied at Schedule 2 of the DPA 2018. I'm not going to go through all of these in turn. It's dealing with the remedies available under the GDPR would be a full talk in itself, but just to touch upon Article 17, which is a right to erasure of personal data in specified circumstances, just to make sure that everyone's still with me. That's the right to be forgotten. You've probably heard about this because it's even if you're new to this area, because it's reported every so often in the newspapers. There's a key case, European Court of Justice case, Google Spain from 2014, 2015. And actually, the most relevant decision, I think, in the UK is the High Court decision of NT1 and NT2 in Google, 2018 case, neutral citation 799. It's Warby J. And that's a case where 2 businessmen with spent convictions were slightly perturbed by the fact that anyone who Googled their names in Google would be taken to prominent search results as regards the spent convictions that they had. They wanted the data removed under the predecessor to Article 17. And Warby J applied the balancing exercise, which is a fair balance between the legitimate interest of internet users in having access to information and a data subject's Article 8 rights, right to private life, right to family life. Those interests, it was said by Warby J, are to be given equal weight. And he said in relation to one businessman, NT1, the public interest outweighed the privacy rights. NT1, as he was anonymized for the proceedings, was a relatively well-known businessman. It was a serious offense, and albeit spent, it was borderline whether or not it was sufficiently serious to have not been a permanent marker on his record under the Rehabilitation of Offenders Act 1974. And NT2, well, actually, this was where there was a marked effect on family life. It was a much less serious allegation, and there was a reasonable expectation of privacy in relation to it. So permission was given for that, the right to be forgotten to be exercised. So as I've said, nothing too groundbreaking about some of these data subject rights, including Article 15 and Article 20, Article 17. But what we're probably most interested in, and we're going to come on to look at, is Article 82. It's the core provision which relates to compensation for material or non-material damage suffered as a result of an infringement of the GDPR. But hold that thought. And because we are briefly going to look at enforcement and the regulatory regime, again, it's a lot of red letter law. You've already heard a lot of about red letter law today. I'm conscious I don't want to overload everyone, but it's equivalent. I mean, I think the best analogy I can give to anyone new to this area is HMRC powers in relation to tax investigations. There's enforcement powers given to the commissioner to give enforcement notices. They require the provision of information to the commissioner. Can be a criminal offence or a civil penalty imposed for a failure to comply with an information notice. There's assessment notices, which again, to allow an assessment of whether there's compliance with the data protection regime. And there's enforcement notices, again, what we see in the tax and planning regimes, a failure to engage properly with the commission or to act recklessly or deliberately mislead can lead to civil penalties. The potential civil penalties are eye-wateringly high. £10 million can be an upper limit. Obviously, we hope for most mundane and everyday, especially accidental one-off breaches, that wouldn't be engaged. But the ICO is empowered under Section 155 of the regime to impose civil penalties for infringement of obligations. And as I've said, the 2018 Act, it retains a number of the statutory offences under the 1998 regime. It also creates further offences there. Just 2 points I'd make. Section 170, which is an offence knowingly or recklessly to obtain, disclose, or procure disclosure of personal data without the consent of the controller. In the case of Shepherd and Commissioner, 2019 neutral citation, page 2, evidential burden on the defendant in those cases. We'll have to see in due course whether that satisfies the Article 6 right to a fair trial. And Section 173, which to me just looks particularly draconian, because given the redaction exercises which data processing controllers have to undertake to edit out any third-party data, to potentially hold a party liable for any sort of inadvertence there does seem draconian indeed. I leave the regulatory regime there, and we're going to focus a little more on litigation matters now. Compensation at Section 13 of the Data Protection Act 1998. You'll see in a second why I go back to the 1998 regime. The Section 13, as enacted, of the Data Protection Act 1998 provided that you could recover for distress, but at Section 13(2)(a), only if the individual also suffers damage, pecuniary damage, by reason of the contravention. And the argument, therefore, was if you suffer distress alone, is that actionable? The Court of Appeal in Vidal Hall and Google, the citations there held that the provisions had to be read compatibly with the EU directive as implemented. That meant that Section 13(2)(a) had to be disapplied. And the headline point was this: a claim for damages for distress alone was actionable. So if you have one of those older legacy claims and there's no psychiatric injury, but there is distress asserted, Google and Vidal Hall, that was compromised before it went to the Court of Appeal. It says claims for damages are actionable even where there's no recognizable psychiatric injury. That's the starting point. We then go forward. And again, this is another Data Protection Act 1998 case, Lloyd and Google. This was a representative action brought by a consumer activist, Richard Lloyd, where again, data breaches by Google. Claimant seeks to recover user damages. And that's damages for loss of control of data in the absence of any allegation of distress or pecuniary loss. So it almost is it actionable per se, as it were. The Court of Appeal says yes in its judgment in 2019. Appeal to the Supreme Court is being heard next month. What the Court of Appeal said in considering whether the intangible loss of control of your data constituted damage was that where the defendant had utilized large amounts of private information without consent, there was serious infringement of a right. There was similar recourse under misuse of private information and other domestic actions, such as breach of confidence, and therefore it would be inappropriate for the court to take a differing approach. Reliance was also placed on the recital 85 of the GDPR, which identified that loss of control over personal data is an example of the kind of damage that might be caused to natural persons as a result of the data breach. So we await next month the Supreme Court to consider whether or not user damages remain recoverable under the 1998 DPA. I think it would be remarkable if even obiter, they don't touch upon how things will operate under the 2018 regime. So we have effectively three tiers under the regime. You have psychiatric injury itself, you have distress short of an actionable, what we call a traditional actionable psychiatric injury claim. And then you have user damages where there's neither distress or psychiatric injury itself. Okay, Article 82 of the GDPR deals with the entitlement to compensation. It's material or non-material damage. There's no ambiguity here about whether you can claim for distress itself. Section 168 of the Data Protection Act makes that clear. You can recover damages for distress alone. Important point to note in passing, Article 82 provides that for joint and several liability of infringers, for example, separate processors and controllers, they're joint and severally liable, but each has a right of contribution between one another. Important to bear in mind if you have a case of that nature. Damages, remedies. Look, I've set out the various cases over the years, starting with Halliday nearly 10 years ago now, which gave what's probably always the off-minded £750 for distress, which is sometimes commonly regarded as sort of the benchmark in these sorts of cases. But actually, what's really the important point to take, it's TLT and Home Office. That says two important things I think about damages for distress. They've got to, the threshold is more than de minimis. That is made very clear. It's paragraph 15 as regards the threshold in the TLT and Home Office case in the High Court. And that as well was reflected in the Lloyd and Google decision by the Court of Appeal at paragraph 54, which said, I understand it to be common ground that the threshold of seriousness ought to be applied to section 13 and misuse of private information. That threshold would undoubtedly exclude, for example, a claim for damages for an accidental one-off data breach that was quickly remedied. But that is far from this case. On the case pleaded, every member of the represented class has had their data deliberately and unlawfully misused for Google's commercial purposes without their consent and in violation of their established right to privacy. But look, Google gives the extreme example. What TLT is very clearly saying is actually in those accidental one-off cases, there will be a de minimis defense available, and it will turn on the evidence of the claimant as to any distress caused. Now, TLT on its facts was 6 asylum seekers who had been put to varying degrees in fear of their own life and their own family security in light of the data breaches. Now, the most serious cases attracted damages over £10,000. The more minor cases attracted awards closer to £2,500 to £3,000. Bearing in mind, in terms of the lower benchmark, it's worth bearing in mind that these are individuals who genuinely believe that their security while in the UK was compromised. So they had to move from an area where they had established shallow routes to an area where they had none. To describe the totality of their experiences as distress is a misstatement and an understatement. I use the word only because it is the label under which damages are assessed in cases of this type. That just sets the framework for those sorts of levels. And I think that fixes, for now, the sorts of awards for damages for distress you see in relation to those certainly non-deliberate or more minor breaches, firmly below sort of £2,500. Court, though, takes its starting point. Gelati and MGN Limited was cited in TLT. The court will take as its starting point the relative personal injury scale of awards. And, I mean, the argument is, if there's no psychiatric injury, you're below the bottom bracket of Chapter 4AD of the Judicial College Guidelines, which I think presently starts at about £2,000. So I think that reflects that. Finally, in this respect, there's a case of Avon and Orbis. I'm not going to pause on it. It's all to do with the Russian and USA secret espionage investigations around the election, relates to transmission of personal data in a national intelligence context. I suspect that won't form part of most of our day-to-day workloads. So I'm going to leave it there, but there's a High Court award of £18,000. Again, it's going to be high given the nature of the information at stake. So in terms of distress, more than de minimis, we're looking at that seriousness threshold. It doesn't speak for itself. Look, I'm going to finish off in the last 4 minutes or so. Common issues in litigation. I think my last slide's a more interesting one than this one, but Morrison's and the various claimants case went to the Supreme Court in 2020. Morrison's were arguing that it wasn't vicariously liable for, it was a former data control, one of its employees who had a data processor who disseminated about 100,000 sets of personal data for individuals on the internet because he was disgruntled with Morrison's. The Supreme Court looked at the vicarious liability principles there beyond the scope of today's talk and said, yes, that's within his field of activity, so you are vicariously liable for him. It's an argument for a different day whether that's right and whether or not you think that the Supreme Court's taken a wrong turn on vicarious liability. I won't go into that. I think it perhaps has in some respects. But its most important point was this. Morrison's has also argued where we've acted reasonably and it's our employee on a frolic of his own, doesn't it undermine the need for fault liability under the Data Protection Act 1998, as replicated in the 2018 Act, that you fix us for strict liability when we've done nothing wrong? We've got all the correct measures in place. This is a employee who we could have done nothing about. And the Supreme Court, unsurprisingly, went back to first principles and said quite often that's the case in a personal injury claim where it's the employee's fault and the employee's done nothing wrong, but there's nothing alien about imposing strict liability, as it were, under vicarious liability principles against an employer. So you will generally be held vicariously liable for the actions of your employee unless you can show that they have acted outside their field of activities. My last slide. Look, I often get asked some of the issues on this page, so it's worth me spending my last 2 minutes dealing with it. County Court v High Court and Fast Track v Small Claims Track. It's sometimes thought that actually the High Court has principal jurisdiction over data protection claims. It will certainly have primary jurisdiction of those claims of higher value or complexity or importance, which are suitable for determination in the High Court. And I've cited the relevant CPR provisions, but it's not an automatic rule that you should be issuing out of the High Court, in my humble opinion. For most claims that we see, it's likely to be the county court by virtue of complexity and value. And I think it's a misreading of CPR 53 to think that you must start in the High Court. And you could be subject to an application to transfer, and there could be cost consequences of that. The next point, Fast Track v Small Claims Track. There's no automatic transfer to the Fast Track or the Small Claims Track, regardless of the value of these claims. It's a fact-specific application of the default rules under parts 26 to 28 of the CPR. Claimants will argue by virtue of the novel complexity issues and potential value of these claims that they go to the fast track or the multi-track. Defendants will say, look, this claim's worth less than £10,000. It must go on the small claims track. There's limited guidance on it, but there is from the end of last year, a recently reported decision. It's the McGoldrick decision. It's Warby J again. It's a neutral citation, 2020 3035. It's a ongoing claim by an accountant employed by PricewaterhouseCoopers, who's raised various grievances against individual members of the HR team and others as regards the handling of a disciplinary action. This was a strikeout application by the defendants. It succeeded in many respects. It did not succeed in relation to an allegation of unlawful data sharing under the Data Protection Act. It didn't do so for one main reason. That's because she had alleged distress in fairly bare terms, but the Mr. Justice Warby said, well, that's actionable. I'm not going to dismiss it on the papers on that particular allegation. But he did thereafter reallocate, well, he transferred the claim to the county court because it was in the High Court, And he also said there is nothing which stops this low value claim being reallocated to the small claims track. So it's a slightly offhanded comment, paragraph 124, as regards reallocation to the small claims track, but particularly if you're a defendant, an important judgment to consider. I end finally with a reference to limitation there. All beware of the pitfall of introducing a actionable personal injury claim. The 3-year special regime can apply even if otherwise a different length of limitation period might apply to the statutory tort once you introduce an actionable personal injury claim under section 11. That has been a slight whistle stop tour from my point of view. I've just brought it in on time. Emily, our HR lady's not going to forgive me for sharing my screen with the unformatted old typo ridden version of the PowerPoint. But Emily, forgive me. I'm giving you a public apology on that front. I hope everyone has found that to be of some assistance. I'm just checking if there's any Q&A questions. You've all been very kind and thrown no curveballs at James and I. So look, some of you probably already started logging off. That is the talk complete. If anyone has any questions, feel free to type them in now. We will loiter sort of awkwardly and I'll keep talking, which I find easy as counsel, until any questions might appear. James has just unmuted himself. From our point of view, we're finding data protection claims are an ever increasing source of litigation. I think the courts are still relatively unfamiliar with these claims. I think they tend to be put on the fast track for that reason at the moment.
Here's a question, James. Oh, no, it's Victoria saying no questions, but thank you very much for the talk.
That is my kind of question, Victoria. Thank you.
You can ignore my last.
Dawn, what does the horizon hold for these claims? James, any immediate thoughts while I gather mine?
Well, I think, Dawn, that the McGoldrick judgment is, I echo what James said, that it's an important one for defendants, and what the Supreme Court has to say about whether distress and the loss of the right to control data is something which is actionable. Because I think the point about degree that James makes is spot on. Start with an actionable personal injury at the top and you work your way down. You're starting from, even in the most serious cases, even an Orbis or TLT, not very much as we as personal injury lawyers know what in terms of valuation of a claim.
Indeed. I mean, it's going to be a growth area. I mean, it gets labeled various things, but I think there'll be a boom. I think people will be pivoting away. I mean, just the marketplace in terms of the work we all do will be pivoting towards claims of this nature. Just looking at two of these other questions, Mark's question, do you think you can gain an award of psych distress and loss of control under separate heads? I think the answer in relation to separate awards for psychiatric injury and or distress is no. There'll be one composite award. The authorities are pretty clear on that. If you look at the Gelati and MGN case in the Court of Appeal deals with that and talks about one composite award. TLT and Home Office picks that up. Loss of control. I think we'll have to wait to see what the Supreme Court says in that respect. I mean, they heavily overlap, don't they? So, but I think well, who knows? But we should get some clear guidance on whether you get a separate head of damages each time for loss of control. We'll have to see. Would quox apply to a claim for distress? Well, this is an interesting point, which I considered when I prepped the questions. So I suppose distress is arguably short of a recognizable nervous shock disorder, to quote the classic authority of Nichols and Rushton from 1991. So if you haven't got a recognizable psych injury, it's not a personal injury, and therefore quox might not bite in relation to the claim for distress. That would be my initial observation on that.
I agree with that as well. Completely agree with it. And then after Mark's question, James, an anonymous attendee has asked if something is a one-off accidental breach, and has given the example of copying someone into an email rather than BCCing, do you believe that would meet the de minimis threshold for a distress award with no financial or other loss? Well, it is arguably, I think, as James has said, that all turns on whether, as a matter of fact, the claimant did suffer distress. But if it's only one instance and it is accidental, then the Lloyd case in the Court of Appeal, as James has set out, says that it's likely to be excluded from an actionable data breach. But as I think the answer is it depends. It depends on how convincing the claimant is on that, whether there was distress and what kind of claimant it is. If it's a vulnerable claimant who is going to have the court's sympathy, then you're on risky territory as a defendant controller, in my view. But you've got a good argument.
Yeah, and I think it also depends upon the nature of the information, doesn't it? You see, the argument's there. I think there's going to be a focus, and I think there'll be more authorities dealing with distress, because I think it's going to be subject to what the Supreme Court potentially says next month. It's certainly weaponized now. I've seen it in various cases. I think claimants know what they're looking for in terms of the data breaches, and the cynic might say sometimes it's surprising what distress there is. Obviously, it's important to have good policies, recall the email, offer an instant apology, reassure it won't happen again, etc. And the court, again, in those circumstances, tends to say they'll give you the benefit of the doubt.
Here's some more, James. Peter has asked, should you or can you not pursue non-monetary remedies along with damages claims in order to escape the small claims track, such as undertaking that the defendant will destroy data in accordance with the GDPR? So I think the answer, as James has already touched upon, it is this is all a question of degree, and it all turns on the extent of the harm which has been suffered consequent on the breach. But a distress claim, in addition to a personal injury claim, you might argue is sort of, it's getting you up into the region which might get you up over 10 grand, isn't it, James? But I'd be a little bit uneasy about that, frankly.
Yeah, again, it's something it's a point I've looked at when I've been preparing this talk, and sort of in terms of the non-monetary remedies, I actually don't see non-monetary remedies pleaded as often as you might expect in these sorts of cases. The focus is they are generally pleaded as claims for the pecuniary loss or distress claims. So I think that's viable. It's obviously going to depend upon particular facts whether or not there's any meat to any alternative remedies. Now, the reality is you might be just dressing up your monetary claim with that particular sort of remedy when it's not needed, and the court might see through it an allocation hearing, I suppose. I mean, I think there's bound to be a large number of these points tested allocation hearings over the next 2 or 3 years, I suspect, and traction will be gained one way or another. And if there's enough volume, I suspect we'll get some form of, whether it's guidance from a DCJ somewhere or from the QBD, which will give some traction to it, because I suspect that people like Warby J as well don't want the £10,000 claims in the High Court either.
I agree with that, and it'll probably be like credit hire and a certain court's practice. Once you've had enough district judges testing these points and then allocating to a certain track, that'll probably give you the answer, and with some guidance from a more senior judge. We've got more. Rob Hams, James, asks, are these claims, including a claim for distress, reportable to the crew? Good question. My instinctively, my answer is that it probably not, because the relevant legislation which covers those items which have to be given credit for by the claimant and paid back to by the defendant, that is to the crew, probably doesn't incorporate a claim for distress, is my instinctive answer. I don't know that to be right, but I think it probably is right. What do you think, James?
Yeah, I mean, obviously, if you've got evidence that there's an actionable psych injury, it will be reportable. But I think a distress claim in itself wouldn't be.
Christian, do you need medical evidence if you're simply claiming distress? I think, Christian, your instinct is you're right. You probably don't, but it could be helpful. But what is distress, as James said, it is not, as Nichols and Rushton holds, an actionable psychiatric injury. If it were a claim for personal injury damages, then you'd be saying as a defendant, strike that out, please. All turns on what the claimant says, I think, is the answer that James and I are going back to, isn't it?
Yes, I mean, it's in simple terms, it can be the lay evidence of the claimant kind of get you over the distress threshold. There'll be those cases where on instructions you might be obliged to refer to a psych for an opinion. If it's particularly borderline, you might get a supportive opinion, but there's a recognizable disorder. The psych expert might simply say it falls short of recognizable disorder, but there's anxiety, depression, etc. here. So yeah, but you don't need it per se to prove it.
Last one, James, that came in at 5:36 anonymously. What is counsel's view about the requirement to keep accurate personal data in the context of records kept by social service child abuse allegations? If an allegation is made and logged in records, then the allegation later found to have been untrue, can the person who the allegation has been made against bring a claim against social services for including an untrue allegation in records? Well, you might be onto something here insofar as data under Article 5 has to be accurate, and if it's made and logged in the records, let's work this through, then it is being processed by the controller. Does the controller, if then it's found to have been untrue, have any obligation to remove it? My instinct is it is arguably yes, that it is then an actionable claim for the breach of the data protection principles under Article 5. It might be. Next question, what damage has it caused? Again, that's a fact-sensitive question, it seems to me. So the short answer is it might be an arguable breach of Article 5. What do you think of that, James?
There's, in terms of the lawfulness, I mean, it's been processed for a legitimate interest, hasn't it? In particular, where the data subject's a child. I mean, it's the sort. I mean, it seems to more closely engage the right for erasure of information, actually, rather than placing you per se in breach for holding it.
Get rid of data that you've processed lawfully, rather than you're in breach for not lawfully processing the data. Yeah, I quite like that too. It's probably a better answer, actually, thinking about it. We are now at nearly 5:45, having had 11 questions after James invited them. More fool him. Would anybody else like to ask any questions?
Certainly wasn't expecting 11 questions.
Take silence as some kind of implied consent. Oh, here we go. No, I spoke too soon. Here's another one, James. Jared asks, is malicious disclosure by an employee relevant? Well, the Morrison's case, if presumably it's disclosure of personal data made without some kind of justification for that processing, so you'll have to show that it's been processed lawfully. But if it's done, and this is a situation that comes up routinely, if an employee does it intentionally and it's done without the data subject's consent, then that's the kind of situation, as James has touched on, whether it's right or not, that the Morrison's case catches, isn't it?
So in the Morrison's case, it was the individual who shares the data. I forget his precise role, but he had access to he was meant to have access to that data to process it. So it fell well within his field of activities on the view of the Supreme Court. So there will be cases where it's malicious disclosure, but if they've gone well beyond their field of activities to get hold of it, you may well have a vicarious liability defense, as it were, that you're not vicariously liable. But again, they're in a pretty wide scope in terms of the application of VL principles these days.
I agree with James. I'm not sure whether the Supreme Court took the right step in expanding the scope of the vicarious liability of a supermarket in a situation where, having done everything else it could have done, a sophisticated and deliberate employee then processes information to cause harm. But that's what the law is. Dawn also asks, is there a difference with Morrison's, I assume she means the Morrison's case, and GP receptionists checking family friends and then disclosing?
Well, the GP receptionist, as part of her role, will probably have been given at least some permissions in relation to looking at the data. So again, it's it's always easy to give really obvious examples, but you've got the cleaner who comes into the GP offices, steals a password, logs in. You might have a stronger defense in those circumstances, as long as you've got good systems in place to stop her getting hold of it. But I think the GP receptionist is probably in trouble as well. It all comes from the Supreme Court taking such a wide approach to matters in the Mahmood and Morrison's case, then disingenuously distinguishing it in a series of cases afterwards. But I think you'd struggle. I mean, I put myself out there on the example you've just given, Dawn. I think you might struggle to say that you are not vicariously liable for the actions of your receptionist in that particular case.
I'm going to put myself out there too. I agree with that. It's in the context of GP records and a receptionist who is acting in the employment of the practice itself. But you'd have an argument, and it would be an argument you'd have to work hard on to persuade the judge that processing was done in the vital interests of the data subject, the claimant, or for the purposes of preventative or occupational medicine. Those, it seems to me, would be the conditions you'd be arguing about. And then the question of what the disclosure was for in the first place would become relevant. But I think James is right. I'm not sure that is a situation outside of the VL doctrine. I think it probably comes within it. I think with that's not prompted any that's not prompted any more questions, James, of the 13 we've had.
We should do Q&A from the start next time, James. Well, look, on that note, let's not tempt fate. Thank you very much, everyone. I think there's still half of you with us. I hope that's been some help. Obviously, drop James and I a line with any particular queries you might have. There'll be a copy of the PowerPoint available to everyone, not the version I used, but the correct version which James was using in the St. John's Chambers colours. And yeah, but well, thank you from me.
And thank you very much from me.